All right. Hi, everyone. This is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for December 16th of 2024.
Almost the holidays.
Yeah, it is. And another interesting week.
Oh,
Hey, everyone. This is
oops.
Curt Barone.
Oh, you're a little
I
back.
missed it. I missed it.
That's okay. The benefits of live. Okay,
Yeah.
so we're going to start with in Houston with probably one of the most disturbing, not the most, but it's an incredibly disturbing set of facts, but they have settled. But what's really disturbing, and I just want to say this is one-sided, if you watch the video that Curt put up and you watch the news, you see the attorneys for the victim, who I'll go through this quickly, but what they say, I just want to be clear, wasn't established at trial. So these are allegations, even though they've settled. So I'm going to repeat things they said. I don't know whether they're true or not, right? This is what they said after settlement. But here's what happened. A former fire captain, female, had made videos of herself and I guess photographs of herself, which were for her husband. This is not like they were posted on OnlyFans or something like that. This was videos of herself. It was on her laptop. And at some point, she had her laptop in her station, and the firefighters went into her laptop without permission, found these videos, and started distributing them. It wasn't until years later that allegedly that she became aware of this when somebody confronted her and told her. As a result of all of this, but I want to get into more, they settled for $850,000. I will tell you that's low. You're in Houston.
Well, Brad, there's one additional fact, and I'm not sure if this got clarified through the proceedings or not, but the firefighter who was accused of sharing the video alleges that he received it via an anonymous email. So that was his explanation about how he came into possession of it. So
Right.
whether a misrouted email or whatever, but that was his initial explanation for how he ended up with it.
And look, we don't know, right? That may be true. Obviously, someone from the department went in and did it. Now that's disturbing, right? That's disturbing because that's not funny. All right, that's just a straight up violation of privacy rights. It's not a little harmless joke or prank.
Sure.
What's more disturbing from you and I's perspective is that when she found out about it, she reported it. It went to allegedly, and I got to keep saying allegedly because there was no trial here, right? It's just a settlement. But apparently, the city HR told her that she should be proud of her body and not to be so worried about it. If that's true, that is disgustingly inappropriate. But nonetheless, the plaintiff's attorneys alleged and stated that the city wasn't taking this seriously. And in fact, they allege, again on this kind of news interview, that the city even attempted to have the plaintiff, the woman, stop seeing her therapist and try to get the therapist to stop treating her, saying there's nothing real going on here. And the reason I said this is probably a very low settlement, because if that was true and if that was, if that really happened, this could have been one for a lot more than that. I mean,
there's an awful lot of issues here, because if she's alleging it was work related, which obviously it was, and now it's workers' comp, now you have the potential defendant in a suit controlling the medical benefits to an employee. And certainly any sort of problems there now get wrapped up into this whole discrimination retaliation concern. So, it's a mess. And this is not unlike the case I believe you and I had talked about. It might have been before we started, the one out of Las Vegas. And I think it was. Actually, I think it goes back to just before we started doing this. Las Vegas had another one. And the reason why I think it's important is this is going to be the new reality that many fire chiefs 10, 15, 20 years from now are going to have to be dealing with the technology. And the reason I said, I was watching 60 Minutes last night, and they talked about, I don't know if you saw it, but artificial intelligence. You take someone's picture and then you're able to turn it into a nude picture. And I'm just waiting. That's going to happen. It is absolutely going to happen. They're going to have a female firefighter, and somebody's going to do that. And not only are we not ready discipline-wise and investigative-wise and
policy-wise,
and policy wise, but at any rate, this is very similar to the case out of Las Vegas where a woman shared an intimate video with another firefighter who she was dating in another department, and somehow the video magically got off his phone. It was on his cell phone. It somehow magically got off his cell phone onto someone else's phone, and then from there it spread virally. And again, we see some similarities here in terms of, I don't know how it got off my device, or I don't know how somebody got it, but and then people have to answer questions, including ranking officers having to answer some difficult questions, such as, did you watch it? Did you get a copy of it? Did you watch it? How many times did you watch it? Where were you when you watched it? What were you doing when you watched it? And why did it take you so long after you watched it to do something to prevent the spread of it?
Right. If it immediately came on, you're like, oh my God, that's inappropriate. I shut it off, deleted it.
And then you immediately do something.
Right.
Okay. But when you watch it and we can get into the Tom Brady problem here of getting rid of your cell phone because you're afraid that there's things on it that you don't, whether it's incriminatory or not, but you certainly don't want other people looking at. But if you're the fire chief, or in the Las Vegas case, they also went after the union president, because the union president, the union executive board have a duty to protect their employees as well. And so we want you to archive your cell phone. And then we want to look at it to see if you received it. Did you watch it? How many times did you watch it? And then how long between the time you first watched it did it take you to actually do something to protect your employee? What a nightmare. What an absolute mind-boggling nightmare.
Yeah. And it's funny. I think the AI issue, it's not much different than drawing a cartoon about somebody, right? And we've seen bullying cases where they draw cartoons or pictures or draw things on somebody. So to me, it's the exact same thing. It's bullying. It's bullying and harassment, right? But and it seems to me, if I take your likeness and put it on a nude body, right, which may or may not be yours, it could be anybody's, you could put it on, it's still sexual harassment, right? You can't say it's not harassment based on sex, so it is.
Well, let's be precise on this. This is something I've been emphasizing now in my classes, okay? Sexual harassment is a legal conclusion. It's got to be severe or pervasive, yada, yada, yada. Sexually harassing behavior. And we want to have our policies make it clear that when you engage in sexually harassing behavior, you could be disciplined for sexually harassing behavior. We actually have a case. I got a case, I think we might have talked about it, where a firefighter was accused of sexual harassment. He was found guilty. He challenged it. And on the basis that it was not severe or pervasive, and he won, the discipline was overturned, that what he did was boorish, what he did was inappropriate, but it did not constitute sexual harassment because it was not severe or pervasive. So sexually harassing behavior, and this kind of ties in with the need for our policies to draw that distinction, because we don't want to accuse somebody of committing sexual harassment. Right. We want it to be sexually harassing behavior.
And I would say be careful with the term severe or pervasive. That is the federal law, and that is the law, except in some states like New York State. I think California and Colorado probably have followed suit, where it only needs to be mildly embarrassing, mildly annoying, right? I mean, it's little jokes are no longer jokes in certain states like New York. And so New York has abandoned the severe and pervasive test like other states are going to, which for the fire service is very dangerous. Yeah. Right? Because just mildly annoying or a little bit more than mildly annoying is going to work in state cases, not necessarily.
And why businesses are moving out of states like that.
Yeah, exactly. Right. Exactly. But the fire service, who routinely tells jokes, I'm not justifying it or not, but boy, with a lower standard, so one joke normally under the EEOC or whatever doesn't amount to much. Right. Bad joke. It wasn't pervasive throughout the workplace. Not everybody was making the jokes, but one joke under certain standards like New York could get you.
And I think inappropriate behavior should be actionable as a disciplinary action. Okay.
Yes.
That's different than saying the employer is liable for that.
Operating. Exactly.
And that's kind of scares me about New York now, because you're not saying that you can't be disciplined. If a firefighter says something inappropriate, it's over the line, and the department has rules and regulations that prohibit it, then the firefighter can be disciplined, no question.
Right.
But now we're going beyond that to say that
Awesome.
that the fire department can be held liable for damages because of that. That's
Yeah.
just, that's insane.
Welcome to the
Well-intentioned, well-intentioned, no doubt well-intentioned, but insane nonetheless.
Right. And people pay for that. So,
Yeah.
Okay, well, let's stay on the same theme, but let's head a little, I guess, east and north to Alabama.
Yeah.
And now we have an allegation of sexual harassment and retaliation based on somebody either being gay or being perceived as gay. It doesn't matter. Perception and reality under these laws are the same. Mm-hmm. So this, if true, and I just, let me say at the beginning, when we talk about the allegations, they are so specific and so insane that they're going to come across as inherently credible. Right? This isn't like somebody made a bad joke next to me. Yeah, maybe they did, maybe they didn't. Some of the stuff is way over the top, if true. And since it's so over the top, people may believe it, like people like 6 jury members. So here's what he said. He said he's a recruit, obviously, and has now filed suit. He's alleging normal things, sexual harassment, but along with harassment, discrimination always goes retaliation. And then you have negligent hiring, training, and supervision. Right? To say you should have had a policy, you should have prevented it, all that stuff. He's alleging that he's forced to resign just 6 months on the job with the department. He said he was called names, a lot of jokes about being gay or gay jokes, a lot of comments. They were in group texts, which could be on or off duty, but it doesn't matter here because we're all employees. He was given nicknames, really bad nicknames. And in one, the really disturbing one, I
don't understand half of the nicknames. Rusty. Well, I mean, I don't know where that.
I didn't want to Google it to find out what they meant, frankly, but yeah, I don't get it. And then Rust Bucket, it must mean something, but I don't want to know. And please don't, anyone watching, you don't need to email in with this. I think we're good. Well, in any event, but he said in the first 2 weeks on the job, he was tricked into taking a picture with one of his coworkers. I don't understand this either, but apparently his coworker was naked in bed, had blankets over him, and he takes a picture near him, and the employee throws off the blanket and he's naked.
Only in a firehouse.
Yeah, and hopefully someday never in a firehouse, right? In any event, so there's issues in the shower, as you might imagine, inappropriate texts with pictures sent to him. So look, he was encouraged and told to report the activity, and that is good, right? That's the good part. But then after he made the report, allegedly, to the captain calls a meeting with the guy's shift, and says what happens on the shift stays on the shift. Mm-hmm. I don't get that. In any event,
this is the victim's, so-called victim's
allegation
perspective, and I'm sure that meeting had a lot of other things in it. He chose to cherry pick that one comment out of it, and hopefully the captain also had said we got to knock it off. And this is an issue I get involved in lecturing on, because where does an officer have the ability to try to deal with a problem at his or her level, and when does the officer have to report it up the chain? And that it's difficult. It's really hard. And personally, when there's any sort of allegation of sexual misconduct or sexual harassment, there's certain things that it needs to get reported. But again, departments don't take the time to really train their people and clarify those. And an officer thinks, hey, look, I can handle this. I've handled things like this in the past. I can handle this. And then it blows up.
Right. And if true, comments like what happens here stays here, probably not, the best comment.
It can be flipped against you. And you know what? You have a 45-minute meeting, and they're going to cherry pick the one part of it that's going to go against you.
Exactly. So, and then at the end of this, which is really when this turns hateful, is that they have 110-degree heat and index, right? Alabama, it's not hard to imagine. There was a warning, again, all allegedly, a warning about the index. And normally we know under health and safety, we don't do outdoor training in that type of heat. We don't put on turnout gear in that type of heat, right? We don't exacerbate, because don't forget it. We got to go from training to a call. Now you've dehydrated. Dehydration is a kiss of death to an interior firefighter. Not a good idea. In any event, he said he didn't feel well. The plaintiff said he didn't feel well. As it turns out, he had COVID and he was forced to run. And he didn't do well on this agility test. I don't know why there are tests happening during shifts. So something's a little weird.
Like, what is I saw that term, consumption course.
So it's mass confidence, air consumption, mass confidence.
Okay, well, I didn't know if it was designed to measure how long his cylinder was going to last. Is that what you're trying to evaluate that?
Yeah, so what we do in the just the background, I was a instructor for New York State and could teach the mass confidence course. And it was a 24-hour course, and air consumption drills really it's all about the last 3 minutes. It's teaching you how much work you can do and getting familiar with, okay, I'm bigger, so I suck it down faster, or I'm smaller, and right. But it's really about the last couple of minutes where your vibro alert or your MSA bell or whatever's going off. And to know how much time do I have? How do I control my breathing, skip breathing like divers? And how can I get out? And how much time does it take to get out? So it's about confidence, but also realizing limitations. And normally, the normal drill we do is you walk around and crawl and go up and down a ladder, but things where you can't really get hurt because you're trying to breathe your air down. Some do it in like a CPAT form where they're pulling ceiling or mimicking pulling ceiling. So they are going through the real kind of energy expenditure that you would have, so you could see how your air comes down. But doing that outside is almost, you never do that. And a 110-degree day is very dangerous. So he couldn't do it. And he's ultimately terminated before he was going to the school, right? He's hired and then he was going to be sent out to the academy, and he's terminated before he had the chance. What's strange though is he had already passed CPAT, right? So this shouldn't have been an evaluation. And a consumption course isn't an evaluation. It's not a test. There's no pass or fail. Oh, your air didn't last this long. And I will tell you that when I was doing my instructor course for this course, I went 45 minutes on a 30-minute cylinder. And the problem, I can go very long on air. I don't know what it is, but the problem is I was exhausted because it wasn't running out of air, and I'm still going around. And finally, I'm just trying to take these deep breaths to get rid of it. But you're not, it's not a CPAT. It's not to test anything. Again, no pass or fail. So all of this is a little circumspect to me, and how a shift could actually kind of fail you. So, but I have to tell you something. This is where in my jury mind, I think the plaintiff's attorney got this wrong. Yeah. I'm guessing the plaintiffs, I don't know, right? How do we know? But it just doesn't seem like something that would happen at a fire department. Yeah, forcing someone to be tired and exert themselves, but a consumption test? No. So anyway, but there's no shortage of sexual harassment, discrimination allegations.
No, and this one is it's not unusual. I've got several dozen of them where it's not it's sexual harassment, but same sex, but it's heterosexual sexual harassment between heterosexual male firefighters harassing, I'm assuming, and it wouldn't matter what the victim is, it's still sexual harassment, but heterosexual males can sexually harass heterosexual males.
Yeah, of course. Anyway, if you're the department and you're not actively training people that this isn't acceptable conduct, then you're just playing with fire. Literally, you're just waiting for it to happen. If the chief is not taking an active stance saying this type of conduct will never be permitted, then it's going to happen. Then boys will be boys, and whatever. Okay, let's go to Tennessee. Now, this is such an important case. There are a couple of cases, if you've been a viewer for a while, where I'm like, oh my God, I got a case just like that, and I'm going to write that down, and this is important. This is so important. When I'm saying, because I defend a lot of these discrimination cases, I had 2 this week. So there are some big holdings and little lines in this. So here's what happened. We have a Tennessee fire captain. He resigned. He was facing disciplinary charges in 21. And he claimed he was constructively terminated, right? Basically forced to resign. He claims he was discriminated against based upon a disability, which would be being an alcoholic, I think. And
PTSD. He claims his alcoholism was worsened because of work-related PTSD. So he was subjected to all these, traumatic calls, and that exacerbated his alcoholism. So trying to connect the workers' comp deal to it.
Yep. And so right there, we probably have a lot of viewers who in their own department could be like, oh yeah, we have this person, right? Of course. So the department takes the opposite view and said, wait a minute, what you did, you committed misconduct having nothing to do with your alcoholism directly, right? Or your quote unquote alleged disability. And because it happened before or kind of with your claims of that alcoholism and that disability, it's not pretextual, right? So think of it. Let me just say it this way: when you do something as an employee that you can be terminated for, and then 2 minutes later, 2 seconds later, you say, "Oh wait, I have a disability," and you're discriminating. No. Mm-hmm. You did the improper conduct that occurred. You don't get to protect yourself, says the court, basically, just by saying, oh, but I have a disability, and that's what happened. It's so the court looks here and says a couple of important things, which we'll cover, but one important thing is it's not pretextual. You aren't being terminated on a false excuse, right? When we're really terminating you for a disability, when the reason we're terminating you happened before your allegations. And that's what happened here. The court says, there's no pretext. This happened before. So both instances of his misconduct, right, happened before all this. But the court says a couple of things. One, I want to read it. They say, because the department's legitimate basis for plaintiff's termination arose concurrently at the same time with his request for an accommodation, the defendant was not obligated to engage in the interactive process with an employee who was not otherwise qualified for the position with or without reasonable accommodation. In other words, if the employee just came to you and said, listen, I've got PTSD or whatever, I need to be accommodated, and there was no misconduct before that, then yeah, you got to reasonably accommodate an employee. But here, you don't have to start that process when you're already looking at terminating him for some conduct he did before all this. So that was a big deal. I thought that was one of the biggest lines out of here. And people should understand, we get all the time, what if we have an alcoholic who does something because they're drunk? It doesn't matter, right? If you have an ongoing addiction, then the law that would normally protect you, the Rehab Act, doesn't protect you, because that's why you're in rehab. If you're still using, then you're not in rehab, and you're not protected just because you have an addiction or a disease, right? This is different than saying, well, I have a cold, or I have some other thing, and I need to be accommodated for it.
I think we gotta separate the behavior from the condition.
Yes.
Okay. And if you engage in misconduct, the condition isn't going to make it okay. Like, you can't use that as a defense. Okay. So the behavior, I think he had kind of lost his temper and yelled and done a couple of things. So it was that behavior that led to the disciplinary charges. The fact that the condition contributed to that is really irrelevant to the behavior. They don't have to ignore the cause. They can look just at the behavior. So, the behavior is what led to the discipline. And the fact that he has alcoholism. Now, I think what could change the facts is if he had done something and somebody else had done the same thing, and the other person is not an alcoholic, and that person was not disciplined for it.
Sure. That
would be an example of where you're treating him differently because of his condition, or at least it appears you're treating him differently. But when you do something for which if anybody did this, they would be fired.
Yep.
then you can't use your alcoholism as you can't say it's a pretext, because anybody who did that under these circumstances would be terminated.
And, and that leads me to the second really important line I thought from this case. They said, as an initial matter, plaintiff never disclosed his PTSD diagnosis to the defendant at any time prior to his resignation. Well, you can't discriminate against somebody unless you know or perceive them to be disabled. And if you didn't perceive him to be disabled, or you didn't know he was, right? And you would think this is such a crazy holding, but I have to tell you, I had this case. I had this case about 7-8 months ago, and my main defense to the attorney saying, oh, you discriminated, was show me proof, A, that this individual has a disability, and then show me where you told us. And the response was, well, everybody knows. I'm like, okay, who's everybody exactly? Because nobody knew. And now she just came out with saying, oh, I have a disability and you're retaliating against me. For what? We didn't know. So if you're the employee who has a disability, you better make sure your employer actually knows about it if you're going to ask them to accommodate it. You can't accommodate or discriminate against something you don't know. Anyway, I thought that case was really good for those two big points, honestly. And now as we transition from discrimination, which may involve alcoholism, to now just a total thief or crook, we have a former Pennsylvania firefighter who's now facing criminal charges for submitting bogus fire credentials, training credentials, and driving, and he was charged with driving without a license. He was promoted, I guess, upon hiring to captain. I'm guessing he's brought in some type of lateral or something.
Yeah.
He allegedly had all these credentials. And by the way, look, it's not hard to take a basic state fire certification, right, and Photoshop it and change it. But the electronic records, I would have thought somebody would be running reports if you can. I don't know in PA if you can or not, but I presume somebody can run an electronic report of what records you have. In any event, he's now facing, so he drove to calls, right, to emergencies. He supervised crews as a captain with no experience, no training. And so they're going after him criminally, as they should. Forgery, 10 counts of reckless endangerment. They probably could have had that to 100 counts if they wanted. Every time he drove or did a training or went to a call, could have been one. And 10 counts of driving without a license. I will say it once again. Why don't we have criminal background checks in every state, fingerprinted, which go across state lines? Because this guy's going to go to jail and then he's going to go to another state and do the same darn thing. That's what people do. So if assuming this is all true, I hope he gets what's coming to him. Lastly, let's go to Maryland.
Why did we do this one last?
I don't know why we're doing it last, but I just on my notes. I don't know. You put it up this morning.
It's a good one.
Yeah, no. And the funny thing is, it's kind of like all our other cases, but comes together. Maybe it wasn't intentional, but it works out.
There you go.
So the firefighter's alleging that the department failed to accommodate his disability. Step one, remember, your employer needs to know you have a disability, by allowing him to remain at a station, by not allowing him basically to remain in a station with a low call volume. I have to tell you, and I apologize to the person, I'm not attacking you. I'm just a guy, with Curt doing a video show, but I find this really thin. I'm not impressed with this suit.
I agree.
We apologize, right? But there are some glaring omissions to me. And anyway, here's what happened. So the plaintiff, the person suing, alleges he has a mental health disability. Now you've got to, in your claim, say what your disability is. We've seen a couple where they don't allege what their disability is. In any event, he has to have a state or federal qualifying disability. He says he has anxiety and depression, which could qualify. He says that he has panic attacks, which also lead to GI issues. Mm-hmm. And then he said when it's not managed well, it impacts his major life activities. That's a phrase that the ADA and the Rehab Act both use, major life activities. And by the way, a major life activity, it's called a tier 2 major life activity. If you don't have any tier 1s, like you can't drive, you can't eat, you can't sleep, you can't learn, you can't talk, whatever. The second one is you can't work. And so working is a second tier major life activity. In any event, he claims that he it impacted his work, I presume. And he said when he had a problem, his ability to focus created, right. But here's where when he had a problem, he had, problems focusing. And he also says he couldn't manage calls, triage patients, communicate with coworkers, and execute tasks. Now, here's the part I'm going to have a problem with. So he then turns around and alleges two important things. One, it's all under control. And two, that he's able to perform the essential job functions. Here's my problem. If it's all under control and you're able to perform the essential job functions, then why do you need an accommodation? That's first problem. Second, if you can't manage calls or triage patients or communicate with coworkers or execute tasks, right? Because he said his limitation impacts these things. How can you then turn around and say you can do the essential functions of the job? If you can't communicate, remember, 2 in, 2 out, voice or visual. If you can't triage patients, how can you do the essential functions? And so the last problem I have is low call volume doesn't mean minor calls. Right. Low call, right? You could have just 2 calls a year. One's a structure fire, one's a hanging, right? You can't tell me. It doesn't matter.
You can have a low call volume station that on any given day may have a bunch of calls.
Right.
And you can have a high volume station that on a given day doesn't have very many calls at all. You can't go by that. And you've got move up assignments. So you're at a slow station. There's a fire on the other side of the county and you've got to move up and now you're in a busy station. Oh, I got to go home. There's an awful lot of questions here. And again, I don't want to seem unsympathetic to this particular firefighter. And to be honest with you, I've had to deal with firefighters who, I'll show my bias, okay, who have hidden in slow companies, okay? And it never dawned on me that there could be some psychological reason. And I have for that reason, I have a great deal of sympathy for this person because I always assumed, and possibly his department assumed, that it's because he's lazy. And that's, again, I'm showing my bias because I always spent all of my time in busy stations. I prefer to be in busy stations. So, but in this case, assuming that he can establish that he does in fact have a mental disability, then I think the triggering event here was that he was told he was going to be detailed for a shift to a busy station. And his response was, I'm going home sick. Or actually, he was still home and I'm going home sick. I'm not coming in, which that's a terrible. I mean, how can you employ people that are going to do something like that? Okay, on an ordinary day. Now, if he indeed does have a psychological condition, then okay, give him the benefit of the doubt. That raises the question, can we employ somebody like that who can only work in slow stations, which on a given day, we don't know if it's going to be slow enough.
And how can you accommodate? How can you accommodate that?
I don't know. That's the challenge. And again, I don't know if you saw me going for my pager, but we're a slow department. We don't have a lot of runs. Okay, we're getting relocated to another community that's got a fire going. So you don't know. You just don't know. I mean, we're going from a couple of hundred runs a year to a couple of thousand runs a year. And so you just don't know, and trying to manage that is difficult. So again, with having sympathy for his condition, there's a fair question about whether or not he can perform the essential functions.
That was my whole thing. Just something seems strange. You have it under control. Okay, fine. Then no accommodation may be needed necessarily. But again, when it's not under control, you can't do the essential functions of the job. I don't think you can have it both ways.
I know folks, I know the former chief from Howard County. They're not a backwoods fire department by any stretch of the imagination. They're very progressive. They have good training for their officers. So I find some of the allegations here improbable only in terms of how it was handled, because I think that they take this stuff seriously, and I'm sure they've got a very well-trained HR department that would have handled this properly. So we'll see how it all works out. But
Well,
He ended up getting where he wanted to go, by the way. He ended up getting reassigned to a slow company, but they put him there because of a, what do they call it? A hardship um accommodation. They gave him a hardship accommodation, and apparently he wanted a temporary hardship, and he wanted an ADA accommodation, which I don't know what the difference. The end result would be the same, I would
still
think.
accommodated it. I mean,
But
yeah.
does that mean if his station, if maybe the ADA accommodation is that if his station is getting moved up to a busier station because of an emergency, he doesn't have to go? I don't
How do you
know.
even accommodate? Right. I mean, that's such an unreasonable accommodation.
Yeah.
Right. And this is a good point for everyone to remember that the ADA or all disability requires you to reasonably accommodate, not accommodate. There's always an accommodation, right?
Yeah.
What do you do to a blind and deaf firefighter to accommodate them? Get them two more firefighters to go with them, right? And guide them through. But that's not a reasonable accommodation. So that people have to, I hear all the time, oh, they refuse to accommodate me. Yeah, but that doesn't mean anything. It's a half a step, but so we had a lot of all of these cases, disability, harassment, discrimination. We're kind of returning to the roots, so to speak, by 70%, as your database shows, 70% of the claims against fire departments are based on discrimination and harassment, and if we could just get that under tow. And
the rest of it just goes smoothly, the emergency stuff. So there really wasn't very much this week in terms of incident related suits. So
good.
there's a couple of apparatus accidents, a couple of discipline, but
yeah, and I have two that I'm going to forward to you. So I got a good decision on one discipline. I got a lawsuit on another. I have some really interesting stuff, and then there's an FLSA one I just filed. So there's some really interesting stuff. It should have come across, but I'll send it your way.
All right.
That's it.
All right. Well, that's going to do it for another edition of Fire Law Roundup. Thank you, everyone. And we will indeed be doing the show next week, just before the holiday. But we'll see you at that point. You're staying in Florida for
I am staying here because I don't know about you, but it's 75 and nice here. So
we had some snow flurries. I'm a kind of a snow guy. I like to get out there with my snowshoes and skis and
I like to do that once a year. So.
All right. Well, that's going to do it for another edition of Fire Law Roundup. We'll see you.